Have a seat, please. Dr. Eno.
Thank you, Honorable President. Honorable President, this is a sitting of the court for the delivery of judgment in the matter of African Commission on Human and People's Rights versus the Republic of Kenya. Honorable President, both parties are duly represented at this sitting. Thank you, sir.
Thank you, Mr. Registrar. Thank you, Counsel Donald Deya, and welcome to the counsels for recurrent and defendant respondent. The judgment will be delivered by Honorable Justice Augustino Ramadani.
Thank you, Mr. President. I'm going to read the unanimous judgment of the court, not only of we who are here, but also the three other judges who are not with us for some other reasons. The applicant is the African Commission on Human and People's Rights, hereinafter referred to as the applicant or the commission. The applicant filed this application pursuant to sub-article 1 of Article 5 and paragraph A of the protocol. The respondent is the Republic of Kenya, herein referred to as the respondent. The respondent became a party to the African Charter on Human and People's Rights, hereinafter referred to as the Charter, on 25th July 2000, to the Protocol on 4th February 2004, and to both the International Covenant on Civil and Political Rights, hereinafter referred to as the ACHPR, and the International Covenant on Economic, Social, and Cultural Rights, hereinafter referred to as the ICESCR, on 23rd March 1972. On 14th November 2009, the Commission received a communication from the Center for Minority Rights Development, SEMI-RIGHT, joined by the Minority Rights Group International, MRGPI, both acting on behalf of the Oge community of the Mount Forest. The communication concerned the eviction notice issued by the Kenya Forest Service in October 2009, which required the Oge community and other settlers of the Mau Forest to leave the area within 30 days. On 23rd November 2009, the Commission, citing the far-reaching implications on the political, social, and economic survival of the Oge community and its potential irreparable harm if the eviction notice was carried out, issued an order for the provincial measures requesting the respondent to suspend implementation of the eviction notice. On 12th July 2012, following the lack of response from the respondent, the Commission seized this court with the present application pursuant to paragraph A, sub-article 1 of Article 5 of the Protocol. Facts of the matter. The application relates to the Oge community of the Mau Forest. The applicant alleges that the Oge are an indigenous minority ethnic group in Kenya comprising about 20,000 members, about 15,000 of whom inhabit the Greater Mau Forest Complex, a landmass of about 400,000 hectares, straddling about 7 administrative districts of the respondent's territory. According to the applicant, in October 2009, through the Kenya Forest Service, the respondent issued a 30-day eviction notice to the Ogieks and other settlers of the Mau Forest, demanding that they leave the forest. The applicant states that the eviction notice was issued on the ground that the forest constitutes a reserve water catchment zone and was in any event part of government land under Section 4 of the Government Land Act. The applicant states further that the Forest Service's action failed to take into account the importance of the Mau Forest for the survival of the Ogieks, and that the latter were not involved in the decision leading to their eviction. The applicant contends that the Ogieks have been subjected to several eviction measures since the colonial period, which continued after the independence of the respondent. According to the applicant, the October 2009 eviction notice is a perpetuation of the historical injustices suffered by the Ogieks. The applicant further avers that the Ogieks have consistently raised objection to these evictions with local and national administrations, task forces, and commissions, and have instituted judicial proceedings to no avail. On the basis of the foregoing, the applicant alleges violations of Article 1, 2, 4, 8, 14, 17, sub-article 2 and sub-article 3, 21 and 22 of the Charter. At its 36th ordinary session, held from 9 to 27 March 2015, the court decided to propose to the parties that they engage in amicable settlement pursuant to Article 9 of the Protocol and Rule 57 of its rules. Since the attempt to settle the matter amicably did not succeed, at its 40th ordinary session, held from 29th February to 18th March 2016, the court decided to proceed with consideration of the application and issue the present judgment. We shall go to the jurisdiction of the court. In accordance with sub-rule 1 rule of Rule 39 of the rules, the court shall conduct a preliminary examination of its jurisdiction before dealing with the merits of the application. After submissions from both parties, the court finds that it has material, temporal, and personal jurisdictions. The respondent raised two sets of objections to the admissibility of the application. The first set deals with objections relating to the preliminary procedures before the African Commission and the court, while the second set deals with the objections based on the non-compliance with the requirements of the admissibility enshrined in the Charter and the rules. Objections relating to some preliminary procedures. The respondent raised two objections under this head, namely that the application is still pending before the Commission and that the court did not undertake a preliminary examination of its admissibility in accordance with Rule 39 of its rules. With regard to the objection by the respondent that the matter is pending before the Commission, the court notes that the applicant in the present matter is the Commission, which seized the court in conformity with Sub-Article 1 of Article 5 of the Protocol. Having seized the court, the Commission decided not to examine the matter itself. The seizure of the court by the Commission signifies in effect that the matter is no longer pending before the Commission, and there is therefore no parallel procedure before the Commission on the one hand and the court on the other. The respondent's objection to the admissibility on the grounds that this matter is pending before the Commission is thus dismissed. Objection with respect to the failure to undertake preliminary examination of its admissibility. The court observes that even though the rules of the admissibility applied by the Commission and this court are substantially similar, the admissibility procedures with respect to an application filed before the Commission and this court are distinct and shall not be conflicted. Accordingly, the court is of the view that that admissibility and other procedures relating to a complaint before the Commission are not necessarily relevant in determining the admissibility of an application before the court. In any event, as in the case with its jurisdiction, the court can decide on the admissibility of an application before it only after having heard from the parties. The respondent's objection is therefore dismissed. Objections on admissibility based on the requirements of the Charter and the rules. The court reiterates that pursuant to paragraph A of Sub-Article 1 of Article 5 of the Protocol, the Commission is the legal entity recognized before this court and an applicant and is entitled to bring this application. Since the Commission, rather than the original complainants before the Commission, is the applicant before this court, the latter needs not concern itself with the identity of the original complainants before the Commission in determining the admissibility of the application. Accordingly, the contention that the original complainants did not disclose the identity of aggrieved members of the OGICs lacks merit. Therefore, the original complainant's observer status and where or not they were mandated and whether or not they were mandated to represent the OGIC population before the Commission are also immaterial to the court's determination of the applicant's standing to file this application before this court. The court consequently concludes that the respondent's objection on this point lacks merit and is dismissed. Objection on non-compliance with sub-rule 5 of Rule 40 of the rules, that is exhaustion of local remedies. The court assessment is that any application filed before this court must comply with the requirement of exhaustion of local remedies. The rule of exhaustion of domestic remedies reinforces and maintains the primacy of the domestic system in the protection of human rights vis-à-vis the court. The court notes that Sub-Article 5 of Article 56 of the Charter and Sub-Article 5, Sub-Rule 5 of Rule 40 of the rules require that for local remedies to be exhausted, they must be available and should not be unduly prolonged. In its earlier judgments, the court has decided that domestic remedies to be exhausted must be available, effective, and sufficient, and must not be unduly prolonged. The court also emphasizes that the rule of exhaustion of local remedies does not in principle require that a matter brought before the court must also have been brought before the domestic courts by the same applicant. What must rather be demonstrated is that before a matter is filed before an international human rights body like this court, the correspondent has had an opportunity to deal with such a matter through the appropriate domestic proceedings. Once an applicant proves that a matter has passed through the appropriate domestic judicial proceedings, the requirement of the exhaustion of local remedies shall be presumed to be satisfied, even though the same applicant before this court did not itself file the matter before the domestic court. In the instant application, the court notes that the applicant has provided evidence that members of the OGIC community have litigated several cases before the national courts of the respondent. Some have been concluded against the OGIC and some are still pending. In the circumstances, the respondent can thus reasonably be considered to have had the opportunity to address the matter before it was brought before this court. Furthermore, from available records, the court notes that some cases filed before national courts were unduly prolonged, some taking 10 to 17 years before being completed or were still pending at the time this application was filed. In this regard, the court observes that the nature of the judicial procedures and the role played by the parties therein in the domestic system could affect the pace at which proceedings may be completed. In the instant application, the records before this court show that the prolonged proceedings before the domestic courts were largely occasioned by the actions of the respondents, including numerous absences during court proceedings and failure to timely defend its case. In view of this, the court holds that the respondent's contention imputing the inordinate delays in the domestic system to the adversarial nature of its judicial procedures is not plausible. Regarding the possibility for the original complainants to have seized the respondent's National Human Rights Commission with the alleged violation, the court notes that the said commission does not have any judicial powers. The functions of the National Human Rights Commission are to resolve conflicts by fostering reconciliation and issuing recommendations to appropriate state organs. This court has consistently held that for purpose of exhaustion of local remedies, available domestic remedies shall be judicial. In the instant case, the remedy the respondent is requesting the applicant to exhaust, that is, procedures before the National Human Rights Commission, is not judicial. In view of the above, the court rules that the application meets the requirements of sub-article 5 of Article 56 of the Charter and sub-rule 5 of Rule 40 of the rules. Compliance with rules sub-rule 2 of Rule 40, sub-rule 3 of Rule 40, sub-rule 4 of Rule 40, sub-rule 6 of Rule 40, and sub-rule 7 of Rule 40 of the rules. The court notes that the issue of compliance with the above-mentioned rules is not in contention, and nothing in the parties' submissions indicates that they have not been complied with.